tātou mā, ko tuku ke mai ki au te honore ki te whakapuarea kei tō tātou noho ki te inoi, e te akatau mai a koutou ki roto i tēnei noho a tātou. Nā reira hei aka tima tātou tō tātou noho ki a inoi tātou. E pāe tau matu ni te rangi. Tēnei hoki mātua au ponanga e koropiko a kei nei mui tu waro e whakamoimisi tūna nei te oingoa. Ko koe ki pā whakahui mai a mātou ko nei tēnei ata. Nā reira ko te ina tike a koe kia tuku koe te māramatanga ki ngā roia, ko uri mai ki roto i tēnei noho a mātou. Me te whakahono atu ki wene ko hono mai marunga i te ipurangi te rānei. Tuku koe te māramatanga ki a mātou, ki te tātari ngā kōrero, ki te whakarongo hoki, ki pai i te hopunga ngā kōrero, ki a puta aku ne pai ngāno, mo ngā iwi katoa e kai pā ngāne ki tēnei kaupapa. Ko tēnei te inuti ki a koe pā ki a tata tonu koe ki a mātou, ki a piri tonu koe ki a mātou, mo te roa ngā ke o tēnei noho, i runga nei te ingoa tāu tama te kai whakoro koe i Karaiti. Amen. Nā reira ngā reo e ngā mana e ngā waka, e ngā tini kārangaranga, tae te a koutou e hono mai rai rungu i te ipurangi, me koutou hoke ngā roia e noho a nei roto i te whare nei, tēnā rā koutou nau mai, haere mai, piki mai, whakauru mai ki roto i tēnei noho a tātou, te rōpū whakamana i te tiriti, i raro i te whakahaere a te kaiwhakawā meo e noho a nei te rānei. Nā reira nau mai, haere mai me ngā itua mahaere ngui a koutou e hinga atu nei, hinga atu nā roto ngā tini mara e te motu, e tirara mai nei ko i ko. Aira taki tini hoki rātou ko wheturangi tia, ko tai atu te oki-okinga, ko tahi tonu ni te kōru mō rātou, ko tai atu rātou i te oki-okinga ki te wāhi tūtū mō tātou, nā reira e ngā mate haere, uti atu. Nau mai rā ki tēnei noho a tēnei rōpū, rapu kia nau i roto i auna e aha nei te whakamauri nei mo te climate change, tai paitaku hakapai, ka titiro ake ngā waipuke, ka titiro ake te āwha, te āwhiowhio, me te kainga te whenua te rā, tai pau ki hakapai ko te riri a tāwhiri mātea. Ko e tēnā te utu ko tai mai ki runga i a tātou, engari harake reu, ki hai au, haere mai ki te kauwhau i a koutou, engari kōro kia nau ngā whakaaro i roto tōku whatu manawa i tēnei wā. Nā reira kau ke kū mea koe nui ni mihi kia roho ni mihi whakatau mai, whakauru mai ki roto i tēnei noho a tātou. Huri mnoa, tēnā koutou ki ora tātou.
Karangara, tātou katoa.
Tēnā koutou, tēnā tātou katoa. E tautoko ana i te mihi I mihia I te ata nei. Tāku he mihi poto kia koutou. Ki ngā kaitono, ngā kaitiaki o te taiao, me o rātou roia. Ki te karauna, me ona māngai, hoki. Nā te karanga a tātou mokopuni kaue mai ki konei, ki te rapu huarahi pai, ki te tiaki o tō rātou hiki mai. Nā reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. I'm just going to ask, first of all, for Ms. Sykes to give her appearances as she's due in the Court of Appeal, and if you would like to do that now.
Kia ora, kei te tautoko I te tohunga I whakatūwhera o tātou nei hui te rānei, kei te whakahoki te mihi, ki tēnei kaupapa hohunu o te ao mō tātou katoa, tiwi Māori me tiwi Pākehā. He hohunu hoki o whakatau I a tātou I te ata nei. Koutou mā I kite mai I te purangi aroha mai, aroha nā te mea kāreau I konei mo te wānei. Kei konei tētai o taku roia Sam Vincent. Ko tākuna inoi kia koutou hei hāpai aia, nā te mea koinei te wā I tuatahi I tai atu ia I mua I te tribunal hei takato kaupapa mō tātou. Ka huri atu au ki tērā o ngā reo. May it please the tribunal, I appear today for 2 claims, and I'm very fortunate that one of the principal claimants that I appear for, Ms. Colleen Skerritt-White, for and on behalf of one of the hapu of Ngāti Pikiao, Ngāti Te Rangi Unora, is here present with me, together with a member of the Ngāti Pikiao Kōika Council. We have 2 claims that we have consolidated into a statement of claim for this inquiry, Y1212 and Y1194. They are long-standing claims that partially settled during the CNI negotiations, and there were extent issues as part of that settlement, and one of them related to these kinds of matters. So we're grateful that we've been made eligible into this inquiry for that. The second is a claim by Ms. Donna Awatere, Y2494. She is the Māori Climate Change Commissioner, and I anticipate that she will actually join us today, but I don't see her. Well, she may be on the live stream YouTube. She is very interested in this matter, and she has been part of the proceedings since the earliest applications were made. I have an apology to make for her instructed counsel, Mr. Scott Fletcher. He's in the High Court today, arguing a rehearing application from the Edwards case, and he seeks his leave to be excused. Again, Mr. Sam Vincent from our office will be here on a watching brief for both claims. We are sincerely apologetic to the tribunal. This is one of our most important claims. Can I just say it in those terms? But unfortunately, the hierarchy of courts has meant that we have to excuse ourselves at this point. I asked my colleagues to help Mr. Vincent. This is his first time in the Waitangi Tribunal. He's mainly working with me for about nearly a year. He's normally in the criminal courts, but is a climate change activist. So we're very lucky to have him as part of the bar. Kia ora.
Thank you, Ms. Sykes, and you're excused. Thank you, Ms. Sykes, you're excused. Just before I take the rest of the appearances, I'd first like to introduce our panel. And actually, I'm not sure that I need to introduce them, but it's proper that I do so. So to my left, we have Mr. Kevin Prime, and I'm sure you will be aware that he has been a long time commissioner for the Environment Court, and that particular work for him has finished, and we're very lucky to have him on the Waitangi Tribunal. I should note again, as per the directions that have been sent, that Mr. Prime is no longer a named claimant. He was removed as a named claimant some time ago, and that I consider that there is no conflict of interest for him to be sitting on this tribunal. Next to Mr. Prime is Professor. Sorry, I was just wondering which of the titles I should call him by. Professor David Williams, and again, a very well-known academic and writer on Māori issues, constitutional issues, and legal issues, and also a member of the Constitutional Tribunal Inquiry panel, as is Mr. Prime. To my right is Mr. Basil Morrison, and has been a long-time tribunal member, and on many tribunal panels, and I can't remember them all, so I'm not going to embarrass myself by trying to go through them. And again, to my mind, a very useful panel member to be having on this particular tribunal, given his experience in local government and as a farmer. Unfortunately, Prue Kapua, who is the other panel member, is not able to be with us today and has given her apologies. She is on her way to give a speech to Harvard at some big global thing. So she has given her apologies, and it's just a pity that she can't be with us today, but she will be joining us in due course, and we had the pleasure of her company and her thoughts and suggestions and ideas at our panel hui that we have had prior to this judicial conference. I also just want to give some introductory comments before I ask for your appearances. The panel has been looking through and considering very carefully the statements of claim and the evidence that has been provided for this inquiry so far. And being aware that there has been an amendment to one of the statements of claim, and also the filing of a joint memorandum of counsel for a grouping of claimants, that has been very helpful to the tribunal in thinking about these matters. However, it has seemed to us that while some of the claims, as Ms. Sykes mentioned in her appearance, are of long standing, it also seems to us that some of the newer claims have been shaped or perhaps impacted by the exigencies of an urgency application. So much more compressed than is possibly necessary for a priority inquiry. So we do have some ideas that we want to discuss with you about areas where there seems to us to be a bit of a gap in terms of both the evidence and perhaps the pleadings. So just to give you an indication of what those are, and still looking at these as being within the bounds of the inquiry as set by the Deputy Chair and as confirmed in the directions that have been sent out. If we go through those issues first, the issues are the physical, spiritual and socio-economic impacts on Māori, the Crown's response to climate change issues, the treaty principles relating to climate change, and it says policy, but also law, policy and practice is within that. And then recommendations on meaningful engagement and consultation with Māori. The recommendations, I think, we really want them to be of real use, real practical use to Crown and iwi Māori. So in terms of the recommendations that we might be looking at in the end, they may include more than just how to engage with Māori, which the Crown has had a lot of experience with in the past, or to encourage the Crown to engage with Māori on this matter and to consult, but also perhaps more detail about some of the things that that engagement needs to include and consider. And we are talking about the future of our tamariki mokopuna, and I just want to quote from, it's a pity Miss Sykes is not here because I did lift it out of her Y2494 statement of claim, paragraph 53, where she's quoting from the Reverend Māori Marsden, and he says there, to abuse and misuse the earth for the sake of a fast buck invites Mother Earth to present the bill and force us to pay. None of us want our mokopuna to have to pay the bill for unmitigated climate change, which we have not adapted for. So we do think that there needs to be a fuller picture, a fuller context in which the treaty principles and their application might have influence. This is a global challenge that every country is facing, and the global situation will impact upon us all, and it is in that context that our recommendations need to be effective or not for iwi Māori and for the Crown and for everyone. So some of the things that we have been thinking of is, can we learn from overseas actions or inactions? What works or not for other Indigenous peoples, and particularly for our cousins in Te Moana Nui a Kiwa. That's a whakapapa and spiritual matter for Māori. What does it mean if we say our spirits leave at Te Rerenga Wairua to go to Hawaii, but the islands that might have been Hawaii, our ancestral home, are not there anymore because they're underwater. So some of those more spiritual aspects, whakapapa aspects, we think can be fleshed out a bit more than they have been if this were an urgency. The other aspect of that is, what might the treaty say about how we live up to our international promises and statements, and particularly in and about our Pacific cousins affected by climate change. So that's one area that global context that we think could be investigated further in this inquiry. A second one is whether we have all the evidence from all the groups we need to hear from. And one of those groups has to be local government, and I'm grateful to Mr. Morrison for raising this with the panel in our hui. Chapter 2 of the emissions reduction plan that was published in 2022 deals with empowering Māori in respect to climate change, and it's good that we have that plan, and that's one of the things we will be asking the Crown to explain further and give further evidence about how that plan is going to be given more effect to. So it's good that we have that, but that we're wondering, is that only at central government level that's going to work? What about the local level? There are many local issues influenced by their locality, and they need local solutions. So this will inevitably involve interactions between local government and Māori, iwi Māori. And just as an example, where marae, for instance, have been red stickered in the Hawke's Bay area, and how are we going to adjust for that sort of issue which has been arising because of climate change and the effect on our weather. Especially when we have marae that are often used in when we have emergencies and so forth, as places of gathering, community action, community protection and so forth. So we think that there's more that might be needed in terms of those sorts of issues. And also insurance and EQC issues for marae. Now, of course, some marae unfortunately cannot afford to be insured, regardless of their trustee responsibilities. But so those are the kinds of more detailed things that we would like to see some evidence for. So we do see this inquiry as a place for a little bit more exploration of these kinds of issues, and we'll discuss them further, I hope, with you as we move through the agenda. So just with those opening remarks, I will now call for council appearances. Who would like to start?
Kai whakawā, tēnā koutou ko Jeremy Prebble aho, kei konei mātou ko Mr. Fong, ko Ms. Seeley, mō te Corona. Tēnā koutou, Your Honour and panel members. Ane taku mihi kia koutou. My name is Jeremy Prebble. I'm here with my colleagues, Mr. Fong and Ms. Seeley, for the Crown in this important matter.
Thank you, Mr. Prebble. Ms. Paul, you're next.
Tēnā koe, I te kai whakawā me ngā mema o te taipura. Tēnā koutou. Council's name is Ms. Paul. I appear with Senior Counsel Ms. Ngā Paul. We appear for 9 claimants, some of whom may join us online in the Zoom. Anthony Fata, Y3280. Denise Mester, Y3345. John Fenwick, Y3344. Katerina Skerritt-White, Y3346. Laurie Porima, Y3283. Mark Ross, Y3284. Merapika Raukawa Tate, Y3347. Tana Boasadine, Y3348. Te Ohu Wikingi, Y3282. Tēnā koutou katoa.
Kia ora, thank you, Ms. Paul. Mr. Fong has been introduced already. Ms. Swedland.
Tēnā koe, te kai whakawā. Mō hoki kia koutou ngā mema o te rōpū whakamana I te tiriti o Waitangi. Tēnā koutou. Ko Ms. Swedland aho. Ka tūnei aho mō Y3278, the Ngāti Ruapani ki Waikare Moana Future Generations Climate Change Claim. Y3279, the Te Upukorehi Future Generations Climate Change Claim. Y3288, the Ngāti Paro ki Hauraki Climate Change Claim, and the combined claim, which is on behalf of Te Waimati Taimai ki Kaikohe. So that includes Y1890, Y421, Y593, Y869, Y1247, and Y138. Tēnā koe.
Tēnā koe, thank you. Ms. Ms. Cherington.
Tēnā koe te kaiwhakawā o te rea kia koutou te straipinara. E tautoko ana hau ngā mihi kua mahia I tēnei ata. He mihi kā tika kia koe matua Kevin. Nā we whakapuare tō tātou nei hui, tō tātou nei kaupapa I tēnei ata. Nei rā te mihi kia koe. Council's name is Miss Cherington, and I appear with Miss Jackson, who is on the screen on behalf of Tuco Law. And we represent 3 claims in this inquiry: Y2397, the Ngāti Hine Forestry Trust; Y682, Te Runanga o Ngāti Hine; and Y1464, Te Kapotai. And I'm just hoping that you got all of that, Your Honour. My screen appears to be delayed.
Thank you. Yes, we did.
Okay.
Ms. Rongo.
Tēnā koe te kaiwhakawā ko I rongo tēnei, I roi ahau mō Ngāti Koata. Met Police Tribunal Council's name is Rongo. I'm here today on behalf of Y3277, which is a claim on behalf of Ngāti Koata. Ngāti Koata were also claimants in the Y262 claim, John Hippolyte being a named claimant. The Y3277 claim is brought on behalf of his daughter, Rahui Katane, and you would have seen from the statement of claim that a huge part of their issues is the tuatara, and the tuatara having its sex determined by soil temperature. So this issue is very important for Ngāti Koata, with 95% of all tuatara in our country found within the rohe. Kia ora mana.
Tēnā koe, thank you. Ms. Wiley.
Tēnā koe te kai whakawā o tira koutou I te rōpū whakamana I te tiriti o Waitangi, me mihi ka tika ki a koutou, I te kai karakia a Mr. Prime I whakawātia ai te huarahi mā tātou I tēnei ata, he mihi tēnei ki a koe. I ngā kai kareme I hapaitia te kaupapa nei I riri aku kupu mihi ki a koutou. Ko Ms. Wiley tēnei, mai te rōpū a Benyon Law, appearing today for Y3262, Miss Emily Bailey on behalf of Climate Justice Taranaki, and Y2139, Mr. Timothy Tukapua and Mr. Dennis Greenland on behalf of the Mua Upoko Tribal Authority. Mr. Benyon too gives his apologies. He's also tied up in the same High Court proceedings as Ms. Sykes. Nō reira, tēnā tātou katoa.
Tēnā koe, thank you. Mr. Vincent has been introduced by Ms. Sykes, but if you would like to just go over the claims that are being represented by Ms. Sykes. I forgot to take the note.
Tēnā koe te kai whakawā. Thank you, I'll do that. Ngā mihi kia koutou, I'm happy to be in front of the tribunal for the first time. So I'm assisting Ms. Sykes with the claim filed by Colleen Skerritt White, that's Y3281, and that is largely relating to Ngāti Pikau. I'm also standing in for Ms. Sykes and Scott Fletcher on the claim filed by Donna Awatere Huata, and that's Y2494. And those are the tēnā koe.
Ms. Seeley.
I've been introduced by my colleague, Mr. Preble.
Oh, thank you. Yes, that's right. Mr. Hewison.
Tēnā koutou, ko Dr. Grant Hewison Takoingwa. My council's name is Dr. Hewison. I represent Mr. Thomas Henry and Ms. Miriana Peka. They have filed claims in an amended statement of claim, and I understand from the registrar those are in the process of being registered and are nearly at that stage. They're both Māori wardens, operate very much at that local level and interacting with a lot of local agencies, local government agencies. So they'll both be very pleased that the inquiry will have a focus on those issues, particularly around emergency management and local responses to the effects of climate change. Thank you, Yura.
Tēnā koe. And Ms. Te Whenua.
Tēnā koe e te kaiwhakawā. Huri no te rōpū whakamana I te tiriti o Waitangi. Koutou ko pai rangatira me o kaimahi. Tēnei aku mahi ki a koutou. Me te karauna anō hoki, me nā aku hoa roia tēnā koutou. Ko te whenua tēnei, e mihi kauanu atu ki a koutou katoa. Kei ko nei ahau hei māngai roia mō te kreme wai 3, 2, 8, 5. Ko te kona kai kōkiri o tērā kreme, tuatahi ko Miss Lani Kiriopa, ko Miss Nikki Douglas, ko Roana Bennett, rātou ko Mariana Terangi, for and on behalf of themselves as representatives of their whānau hapu and iwi and as representatives of Te Uringa o Kia, the Te Arawa Climate Change Working Group. I just, in respect to Your Honour's notes this morning, outlining the key things which the Tribunal would like to hear from during this inquiry, I'd like to take the time just to acknowledge the key māngai, Lani Kiriopa in particular, who is a member of the Ministerial Advisory Committee, the Māori Ministerial Advisory Committee on Climate Change, and she's a well-known climate change advocate within Te Arawa and a researcher with respect to climate change and the environment for Te Arawa Lakes Trust and other Scion and other organisations. She's also a Māori ward councillor here within Rotorua, Te Wāhi e Nohoana nei, Ahawi e nei wā. I'm also today representing Y3286, and that's a claim by Ms. Tui Waimanhoven on behalf of Ngāti Ue Pōhatu. Ms. Tui Waimanhoven is also a very well-respected environmental researcher. She is the current chair of Greenpeace New Zealand. She's an appointed member of the Runanga of Ngāti Porou, and her specialist research areas include the impacts of climate change on the Waiapu catchment area, which is, of course, in the Rotorua area, the area which has been heavily affected by forestry slash, flooded extremely detrimentally to the community twice in and around Cyclone Gabriel and in recent times, and of course their marae, their whare, their papakainga and their urupa are being significantly impacted by the impacts of climate change. Finally, Ma'am, I just would like to note that I was supporting counsel for Barrister Michael Sharp in one of the original claims, Y2607, for and on behalf of Cletus Manupō, or bought by Cletus Manupō and David Potter, now deceased. I don't see Mr. Sharp online, so we'll happily also observe on his behalf today if he's not able to make this judicial conference.
Tēnā koe, Ms. Te Whenua, thank you for that. Just a moment, I'll just check what the situation is. What about Nicole? Right. Thank you for offering to do that, Ms. Te Whenua. We do have Nicole Smith for Mr. Sharp as someone who had given their RSVP. But she is not here today. We will continue, but hopefully, if there's a technical issue, I will get one of the staff to ring and see what's happening, and hopefully they will be able to join us as soon as possible.
Thank you.
All right, so thank you for your appearances. We do have a number, about 8 claims that were filed, new claims that were filed in respect of this inquiry that are still being assessed for eligibility to be included in this inquiry. There are certainly some that are clearly, I shouldn't say this because they're still being assessed, but we have little doubt, in fact, that they will be able to join in the inquiry. So, and the formal notification of that will come out towards the end of this week or perhaps the beginning of next week. So just noting those new claims that are still being assessed. They are Y3340, the Climate Change Totora Nui Nama Ono Trust claim, which Mr. Sharp is the counsel for. Claim number 3344, the Climate Change the Fenwick claim. 3345, the Climate Change Meseta claim. 3346, the Climate Change Skerrit White, this is Katarina Skerrit White claim. 3347, the Raukawa Tate Climate Change claim. 3348, the Boassa Dean Climate Change claim. 2821, the Manawahine Peka claim. And the Henry Climate Change claim, which is still to receive a number. I note that our next agenda item is media requests. This is just a routine item for the agenda. We haven't received any media requests, but just to note that my usual policy for media requests is to allow filming, although this is live streamed today, to allow filming but no audio. If there are any issues that any council have in terms of media requests, this is an opportunity to let me know. Otherwise, there's also leave given to file a memorandum if you do have any issues. So I'll just check now if you could raise your hand if you do have any comments that you wish to make about media requests.
Ma'am, it's Ms. Te Whenua speaking. My hand is raised, although it's not with respect to media requests, but I just would like to inform that Mr. Sharp is wishing to enter the Zoom. So myself, I've personally shared with him the Zoom link, but if the registrar could kindly admit him.
He's in.
Great.
So, Mr. Sharp, if you would like to give your appearance. There you are. Oh, you'll have to unmute, please.
All sorts of technical problems. I was on the YouTube link that was sent me, which wasn't much help to communicate. But no reira. Tēnā koe te kaiwhakawā, anō hoki tēnā koutou te ropa whakamana I te tiriti o Waitangi. Ko Michael Sharp aho. I'm here representing the Y2607 claim, which, as Mr. Whenua said, was filed by Manu Paul and David Potter originally. also Mr. Whenua's counsel on that. Also for the Y3340 Tautarunui Nama Ono Trust claim, which is a trust which has forestry on the East Cape. Nō reira, tēnā koutou katoa.
Tēnā koe, Mr. Sharp, and since you were on the YouTube screening, you'll know all that's happened so far. All right, now one other thing that I should have done and forgot to do is introduce the staff members so that, or I'll ask them to introduce themselves so that you can put a face to the name. And you might have to come within camera. They're all in? Okay.
Tēnā koutou, ko Esther McGill, tōku ingoa. I'm a senior research analyst with the research services team. Kia ora.
Kia ora koutou, ko Ella tōku ingoa. I am an inquiry facilitator on the inquiry facilitation team.
Kia ora koutou, ko Christopher Burke tōku ingoa. I'm the principal facilitator in the facilitation team.
Kia ora koutou, ko Sahara Hesty Broughton tōku ingoa. I'm the claims coordinator for the climate change inquiry.
And just in time to give her introduction.
Tēnā tātou, ko Nell tōku ingoa. I'm the assistant registrar.
All right, thank you, thank you. All right, we're zooming through the agenda because we're not allowed morning tea until 10:30. So I've already talked about the eligibility for the new statements of claim. In terms of the amended statements of claim, as far as I am aware, we have had one amended statement of claim, and that is for Y682, and that is, the amendment is at pages 9 and 10 of the statement of claim. And if I could ask Ms. Cherrington, if you could, I just want to ask a few things about this because the request is for priority to be given to the various issues raised at paragraph 4.3 of your amended statement of claim. So these issues are the introduction of legislation to remove the Auckland fuel tax, cancellation of fuel tax hikes, repealing the Clean Car Discount Scheme by 31st December 2023, stopping work on the Auckland Light Rail project, and any other plan or policy listed in either the Coalition Government's 100-day plan or coalition agreements which impact the environment and or climate change. Now, you've asked for a priority within the priority, and I can indicate that the panel is not keen on that. Would you like to make any submissions as to why we should change our minds about it?
Yes. Yes, Your Honour, thank you for addressing that. I think the way that and we'll speak to it later with the way that when we get to the scope of the inquiry and that issue on the agenda, but I think that probably request can be revised now, and I'd need to seek instruction on that. But given the way that the inquiry is scoped presently, I think those issues would fall within it in terms of that impact on the socio-physical and economic impacts to our clients in that respect. But I suppose we were just noting it there because they were the issues that were being pressed ahead in the Coalition Government's 100-day plan and coalition agreements.
Yeah, so just to be clear,
apologies.
Yeah, you're going to seek instructions, but perhaps in terms of trying to have this heard and reported on earlier than the other claims, you think there might be a change to that request so that that doesn't need to happen?
Well, I would seek some time, Your Honour, to formalise my instructions and perhaps file a memo to update the tribunal on that. But I think the way that it's framed, it's just issues which impact the current, the current issues before the tribunal as it's presently scoped. So I don't think that would be an issue.
Yes, thank you. Thank you for that. That relieves our minds because, the idea of doing a report and then another report when it's some of these, well, all of these issues have so much connection with all the other issues that are going to be looked at in this inquiry, and then trying to pick it out and deal with it separately didn't appeal at all. Just if I could just make the comment in relation to these matters, we're seeing them more as an issue of how to encourage people to reduce their carbon emissions. And these might be particular instances where the encouragement to reduce carbon emissions has been taken away. And then the question is what's going to replace it, if anything. So, just wondering if there needs to be a recasting of the pleading there a little bit.
Yes, Your Honour, I totally understand, and I suppose that falls into, when we look at what the Crown's response has been in this, like I'm just looking at the scope of the question now, and like you say, these actions in terms of reducing carbon emissions fall into the Crown's actions. So I think if I could have some time, Your Honour, to file a memorandum and perhaps amended pleadings if we need to, that would be greatly appreciated.
All right, certainly. Thank you. All right, so let's press on. And leaping over morning tea, let us go to claimant submissions on inquiry design. As I mentioned earlier, there was a joint memorandum filed by a grouping of claimants with Mr. Sharp, I think, as coordinating counsel, if I can put it that way. Mr. Sharp, did you wish to make any further submissions in relation to the joint memorandum?
Kia ora, Your Honour. I'm happy to speak to it because, as Your Honour said in the introduction, there are issues that you want, as you call, fleshed out or emphasised. A lot of those issues, I think, we've covered in whole or part in the memorandum, but it may be a useful exercise at some stage in this conference just to speak to the memorandum and perhaps discuss the tribunal's response to it.
Yes, if you would like to speak to it now, or did you want? Yeah.
No, certainly.
Yeah.
You can see from the memorandum that we've taken the direction setting out that Your Honour has set out for the scope of the inquiry and tried to break it down into different elements at paragraph 10 of the memo, and the general issues being what are the physical, spiritual, socioeconomic impacts of climate change on Māori? Secondly, what relevant treaty principles should the Crown consider in forming its policy response to address the impacts of climate change on Māori? Thirdly, has the Crown's policy response been consistent with those principles? And lastly, what, if any, recommendations should be made in terms of how the Crown should meaningfully engage and negotiate with Māori on future climate change policies, and whether the Crown should take any further steps to remedy any found breaches. So, the first issue that the tribunal is whether the tribunal considers that is a proper and adequate summary of the scope as set out in the earlier minute. Now, in that regard, you can see that that in the following paragraphs, we've tried to flesh out the individual issues with sub-issues, which I won't discuss in detail here, except to say that once again, the claimants would appreciate the tribunal's view on whether that does adequately flesh out the issues. And I note the various further issues that Your Honour has discussed at the start of this conference, and there may be certainly some issues which we can expand on or emphasise further in setting a final summary of what issues are to be addressed. One issue which I did wish to emphasise, or would like to emphasise, is at paragraph 13D, when we refer to the relevant treaty principles, we refer not only to the treaty principles and treaty obligations of the Crown with regards to climate change, but also the broader common law rights and obligations that Māori have as kaitiaki to protect the natural environment, which perhaps more than any other time in modern times has been challenged by the effects of climate change. So we do wish to bring in that aspect of those kaitiaki rights and obligations that underline and still exist in common law, quite apart from treaty obligation issues. With regards to the issue of whether the policy response has been adequate and consistent at paragraph 14, just note that that's really a movable feast, in that we have a new government. It's been making a number of changes to climate change related policies, and will continue to do so. And also, particularly important is that the government is due in June to set out their emissions reduction plan, which will be significantly changed from the last government's emission reduction plan. So as those policies roll out, and particularly with the new emission reduction plan, it is anticipated that there will be filed some updated submissions, claims, and statement of relevant issues for the tribunal. Just in the last part of the memorandum on the evidence, what we wish to stress is that there has already been a significant amount of evidence filed over time in support of this of these claims going back some years, and the claimants are in the process of providing further and updated evidence on those issues. In particular, with the previous evidence provided by James Renwick as a climate change scientist, he's no longer available since he's on the Climate Change Commission, but we have engaged another climate change scientist to adopt that evidence and update the evidence on the current position with climate change science, the effect it's having on Aotearoa and the rest of the world, and the future effects it will have, which is going to be key in this inquiry. So the overall point that we wish to stress is that the claimants have filed a lot of evidence, will continue to file further updating evidence in the near future as we go, and the aim is to be ready for a priority hearing whenever the tribunal has the time and ability and thinks that the appropriate time is to hold a hearing. Now we've submitted that 2 to 3 weeks hearing time are required. That of course will need to be refined and discussed with the other parties, including the Crown, at the appropriate time. Lastly, a note Your Honour's reference in the directions that the tribunal will be seeking modes of conducting an inquiry which will minimise carbon footprint. Now, from the claimant's point of view, that's something that they certainly support and would want to do, and also from the conceptual point of view, Your Honour, I think it's very important that this inquiry do adopt that approach, given that this is an inquiry of considerable public importance, and it'll be a public attention as which will be really globally the first full-scale inquiry of climate change from an Indigenous perspective. So it's not only in practice but in public appearance that we wish to approach this inquiry in the appropriate way. So that's all I had to say as some initial comments, Your Honour.
Thank you, Mr. Sharp, and particularly thanks for advising us about the next publication of an emissions reduction plan in June, because that does give us a time frame in terms of when we should perhaps ask for amended statements of claim to take into account any issues that arise from that new plan. So thank you for that, and also thank you for referring to those broader common law kaitiaki obligations, because certainly the law in New Zealand has been developing in terms of tikanga and its relationship with the common law system, and it certainly behoves the tribunal to be cognizant of those developments and how they might be taken into account in our report and our recommendations. So thank you for that. I will make some comments about some of the other things perhaps after we've heard from the other council. So is there anyone else who would like to make any submissions in relation to the inquiry design? Before we get to the Crown, that is to say.
Kia ora, Your Honour. Ms. Cherrington here from Tuko Law. I don't have any submissions in respect of the inquiry design, but did just want to raise as an issue, particularly if we are moving towards the AVL sort of pathway, which is, we support, but it's just in regards to translations and provision of reo and for reo and things like that, if we need to do that. So just to make sure that that's available as we progress down that track, particularly if we're having a live transmission for claimants and when providing evidence and things like that. So it's really just a flag rather than a submission, Your Honour.
You'll be aware that there is a translation, or there has been a translation. We haven't spoken te reo since after Mr. Prime and Ms. Sykes comments. So there has been a translation ongoing, and that will be provided for any AVL and in-person hearings. So thank you for that reminder. Anyone else?
Tēnā koe mam, ko Ms. Wiley tēnei. We are one of the parties that supported the joint memo that Mr. Sharp has spoken to. Our only additional observation in terms of scope is that the fact that Māori communities are disproportionately affected by climate change is well accepted across a lot of not only research documents but Crown documents themselves. So in our submission, there doesn't need to be extensive inquiry into the fact that disproportionality already exists. The inquiry needs to focus itself on what the Crown actions have been to address the physical, spiritual and socio-economic impacts of climate change on Māori, and whether they have met the relevant te tiriti requirements.
Thank you, Ms. Wiley. Anyone else?
Tēnā koe, Mum, ko Dr. Hewison tēnei. Just to support your earlier comments or introduction of focus in this inquiry on the role of local government, and very pleased to see Mr. Morrison as one of the panel members with his extensive knowledge of this area. Certainly from the claimant sign representing's perspective, that local interaction, that local government role and responsibilities, particularly for both mitigation and adaptation, are really critical, I think, to understanding this inquiry. We do want to see this inquiry progress quickly in terms of priorities, so I'm hoping that won't hold things up too much. But certainly the role of marae, the role of Māori wardens in adaptation and emergency management aspects, I think are an important part of this inquiry going forward. Thank you, Mark.
Thank you, Mr. Hewison.
Tēnā koe, Mum, Ms. Te Whenua speaking. Mum, I am aware that across the Pacific, representatives of Ariki whānau, for example, the Kinitanga within Aotearoa, New Zealand, and other like whānau are purporting to collectivise and form a climate change committee to consider the impacts of climate change across Te Moana Nui a Kiwa from an Indigenous perspective. And I just wish to inform the Waitangi Tribunal of that, given Your Honour's comments this morning on the fact that what we are speaking of to an issue which is an issue of global interest, and we absolutely are part of a more holistic grouping across the Moana Nui a Kiwa, so that what is determined within and inquired into within this particular inquiry has to have regard to that broader grouping. So I raise it, and I guess it's with respect to other parties who should be heard, or interested parties who may wish to be brought in, or claimant groups such as the Kinitanga, and we'll look to Claimant Council to see how we can reach out to those groups to ensure that the right voices are part of this inquiry process.
Kia ora, thank you, Ms. Te Whenua. That's a very interesting development. And I'm sure that this panel would be interested in hearing about that and what actions or statements might be made by that committee that's being formed. So thank you for that. Anyone else? All right, perhaps if I ask the Crown to make any submissions you might have in relation to those matters, and then we'll make some comments of our own. But just hold on a moment.
There's a couple of specific questions to Mr. Sharp. What stage
Might be a good idea to make it now, and then we'll come back to more general comments. Actually, Mr. Sharp, Professor Williams has some particular questions that he might like to ask, so I've asked him to do that now.
Tēnā koe, Mr. Sharp. I just wanted clarity that when you refer to ngā mātā pono in paragraphs 13 and 14 of your joint memorandum of council, that on each occasion, or each time you refer to those principles, they are the wording as in the Waitangi Tribunal's Y1040 Stage 2 report on Tēnā Rangatiratanga me te Kawanatanga. You don't translate them there, and I'm assuming that you are using them as the Waitangi Tribunal did in the Y1040 report. Is that correct, please?
As far as I'm aware, and given that this is a joint effort in this memorandum, that's correct.
I'd quite like confirmation that there's no new matapono that you've invented that is different from the Y1040 report. I haven't checked them all, but I would quite like that to be done.
Certainly, Professor. Well, I'll get that clarified amongst the claimants and advise the tribunal.
Thank you.
Thank you for that. Mr. Preble.
Thank you, Your Honour. I just would like to address scope and the question of the related issues that the tribunal might inquire into, and then touch on timetabling and the evidence, including hearing length. So we have put in a memorandum that hopefully you have on the 28th of March, which really is primarily targeting the scope question. So just dealing with that first, obviously in terms of the decision on priority, and as confirmed by Your Honour recently, priority was granted for the kaupapa inquiry, and that was raised by various claimants on the physical, spiritual and socio-economic impacts on Māori and the Crown's response.
Mr. Preble, just before you continue, I haven't seen that memorandum.
Sorry, Your Honour, it has been filed with the tribunal. Yes,
that's okay. It'll be there somewhere. But what it really means is, could you go a bit slower?
No, that's absolutely fine. I mean, I will cover the key point coming out of that, which is really in relation to scope of the inquiry, and that was the main thing that we addressed. We addressed two matters in it, and one really is the scope question, and the other was we put forward some suggestions for the tribunal in terms of a climate-friendly inquiry. So I'm not planning on going through those suggestions. What I wanted to focus on really was just expanding on the question of what should be the scope for this priority inquiry. And as has already been determined by the tribunal, there has been a statement around what that scope could include. And as I was saying, the focus was, in terms of that statement from Your Honour recently on the 8th of March, that the focus would be on the various claims, physical, spiritual, socio-economic impacts of climate change on Māori and the Crown's response to that. It also stated the priority inquiry should also focus on relevant treaty principles to be considered in a climate change policy and recommendations for how the Crown should meaningfully engage. And so our position that we took to what the scope was falling out of that is that broadly the inquiry has two key factual elements to this, being the spiritual, physical and socio-economic impacts of climate change on Māori, as well as then the Crown's response. And then flowing out of and looking at those matters, there will be findings, we assume, on what are the relevant treaty principles that apply, has the Crown's action been in breach of those treaty principles, and then recommendations. And as Your Honour has said, for meaningful engagement with Māori and consultation. And I would just say, I agree that ultimately it would be very helpful for them to be practically of use for the Crown and for the claimants. And I think we all share that as a common goal. The key comment, which is coming out of that memorandum that I referred to, that Your Honour obviously hasn't seen, is that a key concern the Crown brings is to determine what is the scope of the Crown's response to climate change. And that's really to explain that the Crown has effectively been responding to climate change for decades, and the Crown's response in terms of this kaupapa inquiry, which has been granted on a priority basis, we say should be therefore limited to the Crown's current as opposed to historic climate-related policy settings. And in saying that, I guess that's our key submission to you. The reasons for that is obviously that there's been priority granted, and the tribunal considered that the inquiry should be tailored in a targeted way. Otherwise, it will be difficult to proceed with the pace envisaged. And we understand that priority is justified because there's a need to address the prejudice caused or avert prejudice in the immediate future. So again, we think focusing on the current settings of the Crown, the current policy and legislative settings, would aid with that, as opposed to looking into historic breaches or historic actions that the Crown has taken in responding to climate change, because obviously it goes back some decades now, at least back to 1992, when climate change really became a known phenomenon, and the Crown started to make steps to respond to it at that point. So that's our primary point that we would wish to reiterate, and that we see the as the claims, in terms of the claims that have been filed, and we've gone through those as well, including some of the amended ones, they are looking at raising things that, as a broad category, give rise to issues regarding the ETS, the Climate Change Response Act, New Zealand's response to relevant international obligations, and so on. And broadly speaking, we do think that the majority of the claims can still be addressed within the context of an inquiry into the Crown's response in a contemporary setting, and looking at the Crown's current responses, given climate change is, as I think the tribunal itself notes, an issue which is rapidly evolving, as is the Crown's response to climate change rapidly evolving. And so we're just wanting ultimately to have something that is most beneficial for the Crown, that's able to fit into what is a changing and quickly changing policy framework. Just on the statements that Your Honour has made this morning about scope, which were helpful, in terms of international aspects, we would see the Crown responding on what it is the Crown is doing in an international forum, as well as a domestic space. But again, just focusing or bringing it back to that being contemporary. In terms of local authorities, we would see them potentially being joined as interested parties, but obviously not to give evidence for the Crown. Alternatively, perhaps the focus could be on what the Crown can do better to support local authorities, as opposed to what local authorities can or should do. So we do draw that distinction in terms of the Crown and local authorities there. And similarly, regarding EQC, would anticipate, if they were to be involved, asking them to join, but not obviously give evidence for the Crown, or again, focus perhaps on what is the Crown doing in that space to support insurance-related matters. And so really just the point I'm making is that for both of those entities, we would want to consider carefully the relationship between the Crown and those entities. And perhaps the other point to note, which I think has already been made, is that involving them may have an impact just on the timing and the ability for this to operate on a priority basis. That was scope. I think the points that have been made by my friend Mr. Sharp In terms of issues, we do broadly agree with the issues that they outline at the high level in their memorandum, which is at paragraph 10. And I guess we had envisaged that perhaps one way forward following this judicial conference was for there to be, perhaps with some indication as to what the tribunal is also interested in, as Joanna has already stated, but there to be some effort on a joint document that might capture what are the key issues for the tribunal that fall out of the scope of this inquiry. And those issues that we say, broadly speaking, we agree with are those set out at 10A through to D, obviously with that caveat that we would want the inquiry to be focused in a contemporary way on what the Crown is doing, if at all possible, to ensure this is going to be meaningful and able to be undertaken on a priority basis. We, moving through that to evidence, would see there being consideration of the evidence more fully once we actually have, I think, a greater degree of agreement and understanding on what is the scope and what are the core key issues that the tribunal will look into. And we think that the evidence is likely to be reasonably extensive on the basis of even the scope being a contemporary one, looking at the Crown's response. We would see there being a need to update the evidence. I note my friend Mr. Sharp referred to evidence filed, but 2017 and 2019, it's going to already be reasonably far out of date, just given the pace at which these matters are changing. And so we do think that evidence, at least from the Crown perspective, will be required on a number of matters, including around the current settings. There's obviously the National Adaptation Plan, the Emissions Reduction Plan, what has the Crown been doing in that space? And we would anticipate the Crown looking closely at evidence related to both the international and domestic level in terms of its response. So we see there being a reasonable amount of evidence. We don't necessarily therefore agree with some of what the claimants are stating in their joint memorandum, which is that it might simply be a situation of compiling publicly available documentation. We think that's slightly overly optimistic and simplistic. We think that it will take a bit of time to pull this together. It is a complex area. And in terms of impacts to Māori and the fact that they are disproportionately affected, we do note that there are statements to that effect in the publicly available documents. But again, we would still also want to consider carefully any evidence and have the opportunity to interrogate that. So there's, from our perspective, the evidence itself is not going to be straightforward and will require some time to ensure that we get meaningful recommendations from the tribunal. And we do note, just falling out of that in terms of the timeframe for the hearing, we do consider that the 2, possibly 3 weeks that has been stated in the joint memorandum from the claimants is too short in our view. And given there's over 20 odd claimant groups that are now joined, as well as the fact that the Crown will have a reasonable amount of evidence, we would have thought there would need to be over 6 weeks for this to be heard. And that really just takes into account the fact that there's going to be contested evidence, and the Crown's evidence itself may well take a week of that, if not more. Those are possibly the main points that I wanted to make, Your Honour, and I did just want to come back to that point that as the joint memorandum itself notes, they set out there that following any indications or directions from the tribunal, the claimants and the Crown could jointly prepare a draft statement of issues. And I would agree with that as a way forward if that's workable for the tribunal, given it may be that there can be an indication as to the kinds of things that, as you've already indicated, things the tribunal are particularly interested in, and the parties could make steps to agree those. I think, as I've noted, there is a reasonable amount of commonality on the broader issues that are outlined in that joint memorandum. So I would hope that perhaps we could work together collectively on something that pulls those issues together, or at least outlines where there might be some differences. Maybe if there's an indication as to when the hearing time is available, that could also then assist the parties for working backwards for a timetabling leading up to that point. And just the last thing I've noticed in terms of the emissions reduction plan, yes, that's right, it goes out for consultation in the middle of the year to be finalised at the end of the year, is my understanding of the broad timing for that document in terms of slotting into potentially influencing when the tribunal might want to have this matter heard.
Thank you, Mr. Preble. You've given us a lot to chew on, I think. So it might be worthwhile to have our break now and then come back at, what is the time? And yes, well, actually, we'll make it till 10:45 because I think Claimant Council might also want to have a bit of a think about comments that they might wish to make, submissions that they might wish to make in response to yours. So we'll take our break and come back at 10:45.
Thank you.
No mai hoki mai. Welcome back to the to our Judicial Conference. Now, there are a number of points made by the Crown, and I think what might be useful at this point is just to go back again to claimants and ask for any responses you might have at this stage. But could I also ask you to address specifically the timetabling, as that is a matter that the Crown has raised, and hearing requirements. One matter that hasn't been addressed as yet is the research requirements. So I've got some things to say about that, but perhaps if we have the responses from Claimant Counsel first, and I might ask you, Mr. Sharp, to respond, then Ms. Wiley, then the next person who puts up their hands would be the next responder.
Kia ora, firstly, like the tribunal, I don't appear to have had the Crown memorandum, but I get the gist of what.
Well, perhaps I should say we have found the Crown memorandum, and if I can ask the Crown, it's a heartfelt plea from the registry that they update the list to which they're filing, because if they just file on the old Waitangi Tribunal registrar thing, there's thousands of documents going on there at the moment. So please file to the distribution list for the Y3325 inquiry.
Thank you, and my apologies for that. And also, just in terms of that, Mr. Sharp, it's not a long document. It really just raised that point that scope was something we wanted to have carefully considered as part of the next steps with this inquiry. And I'll stop there. Thank you, Your Honour.
Thank you. And I have had just a quick email around with the other Claimant Counsel on some of the issues raised. So I'll respond as best I can, but the other Claimant Counsel can also respond. With the issue about whether there should be a focus on contemporary issues and climate change policy, it certainly is the intention of the claimants that the adequacy of current climate change policies, and especially as it relates to Māori, should be the focus of the inquiry, because amongst other things, the claimants are looking for recommendations as to how those policies can be improved. But in saying that, it's still the claimant's position that this should be seen against the context of what they say is the historical failure of the Crown to adequately address climate change and those ongoing historical impacts upon Māori. So that those historical issues are important background to the inquiry as far as the claimants are concerned. With the timetable and the evidence, our estimate was just an estimate based upon what evidence we were looking at producing and being produced. So I agree that once we get a better idea of what evidence is going to be produced, then a more accurate timetable could be formulated. And just let me say also that as noted in our memorandum, a lot of the evidence relates to a lot of relatively technical and expert issues relating to the effects of climate change and the policy response that has occurred. And we've noted in our memorandum that there could be the possibility of once evidence is indicated and filed, some sort of conference of experts and with a view to perhaps producing agreed statements of facts and other issues which all the experts essentially agree on, and so there's no point in multiple experts saying the same thing. With the issue of research, one thing we did raise in our memorandum is that the claimants do believe that they are able to produce sufficient evidence to ground their claims themselves without necessarily having tribunal commission research, but of course, if the tribunal considers that it can and will be able to produce some or commission some further expert evidence or further evidence and reports, then that would be gratefully accepted by the claimants, of course. But the priority is, given the priority hearing, that they don't want the hearing held up by long periods of time spent commissioning and waiting for reports. So that's the comments that I have at this stage, Mark.
Thank you, Mr. Sharp. Ms. Wiley?
Tēnā koe, Mum. Support the submissions made by my friend Mr. Sharp, particularly on the idea of there being a expert evidence that's pulled together to form some kind of agreed statement. Again, reflecting on our submission that we don't need numerous hearing weeks to demonstrate that climate change has disproportionately affected Māori. That is in a number of Crown statements and documents already. Thinking about whether there is merit in the Crown themselves providing a positional response to the claims so that the issues that they see as contested can be focused on for inquiry, but that may best wash out in actually just a expert evidence kind of exchange to really drill down on where the key contested matters lie. Take a slightly different perspective from my friend for the Crown, in that in our submission a compilation of the public documents and expert evidence will go a long way to providing the required evidential base. And reflecting on the number of weeks, maybe there is a need for 1 or 2 hearing additional weeks, but we don't see the need for 6, especially if the Crown's indicating that they intend to just take 1 of those weeks. So yeah, a sort of 3 to 4 weeks hearing timetable and program from our perspective would suffice.
Thank you, Ms. Wiley. Did any of the other Claimant Council wish to make any submissions in response to the Crown's?
Nā koe mā, Ms. Rongo here.
Tēnā koe, Your Honour. Ms. Charrington again for Tuko Law.
Sorry, perhaps if we...
Sorry, you go, Ms. Rongo. Okay.
Ms. Rongo, if you are next, and then Ms. Charrington after that.
Thank you. I'll be quite quickly. My client is listening in, and she suggested she supports the slight changes we're making to the normal tribunal way of doing things, like, for example, having our hearings and meetings by AVL, and she thought instead of having 1 hearing week every 2 months, like is sometimes done, perhaps we bunch some hearing weeks together, and by doing that we may actually hurry the process up. So she's thinking maybe 2 or 3 weeks consecutively, if possible. That was just her suggestion, though.
Thank you, Ms. Rongo. Ms. Cherrington.
Tēnā anō, tātou mā. My submissions are just really in relation to the timing raised by the Crown, and I support Mr. Sharp and Ms. Wiley's comments in this regard, but it's just, I suppose, making sure that we capture enough of the time to get the historical content and the development of policy stages and progress of the Crown's climate response. So those were just the submissions that we wanted to make in respect of that, and just making sure that it does go far back enough to make sure that that's appropriately captured. And again, yeah, I support their comments in terms of research, noting that expert evidence could be provided by our clients too, especially in relation to tikanga evidence, if that's what you were looking into in terms of whakapapa and those comments that you made earlier, Your Honour, that might be helpful. Yeah, those were all the comments that I wanted to make, but supporting Ms. Wiley and Mr. Shah.
All right, thank you, Ms. Cherrington. Anyone else?
Tēnā koe mā, Ms. Te Whenua here. Whilst we support the submissions made by Climate Council and Mr. Sharp, we would reserve our position on whether further research may be required. There may be some express issues that would benefit from further scientific research. For example, our Ms. Wamenhaven in particular, on behalf of Ngāti Uepohatu Y3286, is raising concerns around the current emissions trading scheme and the exclusion of mature native forests from the emissions trading scheme, so that Māori landowners who are kaitiaki and recognised kaitiaki or owners of mature native forest are not able to benefit from carbon trading under the emissions trading scheme, on the basis that the science, which has been used by the Crown and or its agents, states that carbon sequestration is not at a rate which exceeds the decline of that forest. In other words, the falling of trees and the creation of carbon through their deterioration process. So that's a unique issue, and it's one example of the different ways, I would say, this expresses a different Māori worldview, a different tikanga basis in valuing, and it's also discriminatory, specifically against taonga Māori, in the way that we value, not only economically in terms of this carbon sequestration emissions trading scheme, but also physically and metaphysically, spiritually and culturally, our taonga Māori versus a Western perspective. So those kinds of uniquely Māori perspectives towards the solutions to climate change under the Crown's regime and under a Māori regime are the types of things that our clients would like some further analysis into, which may require further research and which may affect the timetable.
Thank you, Ms.
One example, sorry, ma'am. One example, but I'm sure there are others. The other example raised by Lani Kiriopa on behalf of Te Arawa Climate Change Working Group, Y3285, is that all of their solutions that Te Arawa itself has put forward to local government and central government for resourcing and enabling their local communities to advance in a climate sovereign way. For example, to re-tap back into natural energy sources, geothermal energy sources here in Rotorua, have been turned down or otherwise dismissed by Crown resourcing agencies. So it's those analysis into local solutions and the way that So rangatiratanga and giving effect to kaitiakitanga by Māori for Māori, and the way that the Crown has acted and perceived those, which our clients are most concerned with, which may affect the evidence being brought forward. Thank you, ma'am.
Thank you, Ms. Te Whenua. Those are interesting issues. Yes, thank you. Thank you for that. Anyone else?
Tēnā koe, ma'am, Dr. Grant Hewison tēnei. Just in terms of local government, Mr. Morrison no doubt will be aware that local government has had concerns regarding hazard management, climate change, stretching right back into the 1980s and perhaps even before that. And if that is to be a focus, or one of the areas focused on in terms of this inquiry, there might be just a short piece on some of that history that has affected Māori, particularly where developments have gone ahead, where there has been opposition for Māori based on concerns around flooding or based on concerns around the way in which land is developed and the natural hazards. But probably to bring that into a contemporary context, there are these issues of managed retreat and how that is managed, and primarily, again, local authorities are at the forefront of having to address those issues, particularly without any Crown guidance or legislation that sets out how that will occur, and are making decisions that affect Māori and particularly coastal communities without that guidance. So there's a need, I think, there for some historical context to place that local authority focus you want to have so that we're understanding the contemporary nature of the issues that local authorities in Māori are facing, particularly in terms of managed retreat.
So, Dr. Hewison, you are you saying that your client would produce that, or is it that you would be asking the tribunal to commission a relatively brief report, just setting out that context?
I think our clients would be in the position to produce that if it was a relatively brief review of that context. Yes, I can probably commit to that.
Thank you, Dr. Hewison. Any other submissions?
Tēnā koe te kaiwhakawā. Just to note that I support my friend's submissions and particularly echo Ms. Te Whenua that we are unsure if further research would be required, and this would likely to be dependent on, the final issues and evidence produced by and the position of the Crown. And to flag that the claimants do not necessarily have access to the Crown Forestry Rental Trust funding to commission research themselves, and so would need support from either the tribunal or the Crown if this evidence is required. And particularly if there will be a more in-depth analysis of place-by-place evidence, that claimants in different rohe will have distinct relationships with their respective local governments and central governments, and also distinct vulnerabilities to climate change, depending on the ecological profile of their rohe. For example, we have claimants with predominantly coastal whenua and moana, claimants with very much located in the Ngāhere by lakes. Yes, thank you, Mum.
Thank you, Ms. Swedland. I think we have now heard from everybody. Have I missed out anybody? No. All right. Well, thank you for your submissions. I just will start by making a few comments about the hearing requirements, just because they're the easiest. As you will all be aware, the tribunal has a very heavy workload at the moment. I have asked for a certain number of hearing weeks for next in the next financial year, and so I indicate now that we certainly wouldn't be having any hearings this financial year, so it would definitely be after the 1st of July that we would be having hearings. In terms of the possibility of having consecutive hearing weeks, I've had a plea from the panel that that not happen, partly because they are on other panels as well, and also this is their this isn't their main job. They do have other lives and other jobs to do, so it would be very difficult to arrange back-to-back hearing weeks, but definitely appreciate the thought behind the wish to see things move quickly. In terms of the, there is one thing that I would like to ask Mr. Prebble in terms of scope. You mentioned in your submissions that you wish, the Crown wishes this to be a contemporary inquiry and not historical. I just had to understand what you meant by not historical.
Certainly, Your Honour, I was thinking the position the Crown was taking to this is contemporary, is in the sense of looking at what is really in place at the present moment, as opposed to looking at previous policies, regimes dealing with climate change, given if we started to go down that road, I mean, there has been steps to address climate change, whether or not people consider it effective or not, but there has been steps to address climate change since the 90s. And obviously it's a rapidly moving area now with much more sophistication under the CCRA, the Climate Change Response Act. And I guess our intended focus, or our request for a scope focus, was to try and pull it into something that really looked at what is the Crown doing at the moment, what is currently in force, in order to then give the best guidance, I guess, moving forward as to what might need to change. Hopefully that answers your question, but please feel free, if not,
yes,
to ask questions.
I'll just ask a little bit more. So for instance, the ETS, which is a part of Climate Change Response Act and is happening now, that's current. And I'm presuming what you're talking about is possibly things like a failure to provide protections back in the 1980s or something like that. Is that what you mean?
That's totally fair, Your Honour, and I do think that it's hard to put a bright line around this, because we ourselves wondered about exactly how to define what is current and what is not current. And certainly some of the regimes that are no longer in force, we wouldn't be considering within the scope of that, but some of them have been in place for some time. Our focus was, even for those that are in force and have been put in force from some time ago, the focus would still be on them where they're still operative and having an effect now. I accept that some of those regimes, as Your Honour is pointing out, will have been introduced many years ago. But in terms of, I guess, the policy and legislative settings, we are really looking to, or requesting for a focus on what is applicable today. And that is really about, while they might have had a genesis some time ago, we're not focused on those things that really aren't having any operative or applicable effect for the claimants and the public generally at this point in time.
So just picking up Dr. Hewison's point about issues that local government have failed to address in the past as a matter of a contextual thing, rather than as a, well, we can't make claims against local government anyway, but as a contextual background to what is perceived as a gap in Crown action to help local government or guide local government in relation to climate change. You wouldn't see that as not applicable to this inquiry.
Yeah, It's fair. I mean, I think that there's going to be historic material that is background in nature, which will inform the tribunal's assessment as to what is the current settings and whether or not those current settings are appropriate. So I do accept that it's, like I say, there's not a bright line test. I just really was putting forward the request that it be as forward-looking in terms of what is currently in force as possible. But I take your honest point on that, and it partly informs our own thinking about the timing and the length of time required for this, just because some of those issues are complicated, and how we've got to where we've got to does require, if we're going down that track, a little bit of unpicking. So that was why we thought we weren't being overly conservative with the 6 weeks.
All right, thank you, Mr. Preble. Just in terms of that the hearing weeks that we can put to this, I think it is a bit of an iterative process. We'll have to see what the joints. I'm hearing that you're willing to engage in a process of trying to develop a joint statement of issues. Will depend on that and what further evidence is required. Just in terms of the comments you made, Mr. Preble, about the consultation on the new emissions reduction plan, which will be published in June, and that then there's a consultation process. I would see us having the flexibility in this inquiry to have that as an iterative process too, perhaps giving counsel and claimants an opportunity to make the initial responses, which in a way is part of the consultation, to the emissions reduction plan, and then with an opportunity to make further submissions later when the final plan is in place. So I suppose what I'm indicating here is that I don't think we should hold everything up until the end of the year when we know what that policy is definitely going to be. I think we can move through the inquiry using that valuable time that we've got, and the need for, as various claimant counsel have expressed, the need for trying to get some report quickly, given that 2030 is really just around the corner, and that's a big deadline date for what's going to happen to our world. All right. Now, just a few other comments. So I will put out a memorandum asking for counsel to liaise about a joint statement of issues, and then counsel will then have the opportunity to make submissions about any further research or evidence that they think might be necessary in relation to the issues there. I can say that the panel felt that a lot of the sub-issues, I think Mr. Sharp called them, in the joint memorandum of counsel were certainly part of the scope of the inquiry, but we do bear in mind that the issue of whether Māori are disproportionately affected, the Crown wishes to interrogate that further, and I think we do need to put a solid foundation for that, and the compilation of public documents and so forth that was referred to by Ms. Wiley would be very helpful, and I'm going to ask the Crown to do that. And also ask the Crown to... the panel has been discussing the ETS, and there's various aspects of it which are not well understood by the panel, and that means me. One of those things is the auctions and what's happening around them, and where the units that the government is auctioning off comes from, and what the effect of not having people bid in previous auctions. I know they actually bid this time around. Those kinds of things are a really full explanation of the ETS and then how it fits in with any other activities that the Crown is undertaking. So I would ask the Crown to give us that. Just in terms of, there's been a lot in the statements of claim referring to other documentation or other sources, references and so forth. It would be helpful and good for the record to have Claimant Council file any reference materials that they have used in their memoranda, just so that we're all looking at the same thing and are sure that we're all looking at the same thing. I have asked the research unit for the tribunal to do a literature review. So if there are any other documents that you think would be helpful, please do file them, and they will then be able to do a full analysis, which might be helpful certainly for the panel, but helpful for us all. There was just one other. Yes. Mr. Sharp and others have mentioned that I've emphasised certain points in my opening remarks. Can I say that it's not really emphasising over and above any of the other issues that have been pleaded in the statements of claim. It was more where we saw there could be more. It's the fleshing out that we're looking at in terms of the matters that I raised in the beginning of our judicial conference. So I don't want people to think that all those other matters that were pleaded in the statements of claim don't have a priority for the tribunal. They do. It is that there is other areas which I think need a bit more attention. Now, I've asked, and actually one of the matters that I'm not sure I saw in any of the statements of claim is any reference to the UN Declaration on the Rights of Indigenous Peoples. So I would appreciate any evidence or submissions in relation to that as we, further down the track. Now, I'll just ask the panel. I'm sure I've forgotten things that I ought to be saying to you, but I'll just ask the panel if they've got any other things they'd like to pick up on. No. All right. So our next steps will be that that liaison between Council for the joint statement of issues, then further submissions, further memoranda from Council about what further research or evidence they would like to present in relation to those issues, and then probably that would be the best time to have a further judicial conference to see about things like timetabling and hearing needs. So there is just one other thing that I would like to be clear on. If Claimant Council have said that they would, their claimants support, what I've taken it as meaning is that you support AVL, that way of claimants, if they're going to give evidence, would give it over AVL. I do know that, or have the sense from the joint memorandum of Council that, in fact, there might not be a lot of verbatim evidence given, that it would be expert reports, and that perhaps there would only be cross-examination, provided that it would only be on those issues left from the expert from the experts that were actually issues. Is that correct? If you don't need to all go one by one. If you just put up your hand like this to say that your claimants are supportive of the hearings being all by AVL. I'm not saying that they will all be by AVL, but if they're supportive of that.
Mark, can I just say that we have discussed this in our payment SUIs, and it's fair to say that there's broad support for that, but some council have raised reservations about the effectiveness of a hearing by AVL with some types of witnesses. So can we just say that broad support, but some potential reservations as far as I'm...
Okay, thank you, Mr. Sharp. Did anybody else?
Sorry, and Stefan, we're here. Can I clarify that is the question whether we support not only the majority of evidence being provided by AVL, but the majority of evidence being provided by experts as opposed to claimants?
No. We're hoping, certainly in terms of the physical and spiritual aspects of the inquiry, we would certainly hope to hear from, or to have evidence from tangata whenua.
Thank you, ma'am. Yeah. Thank you for that clarity.
I think what Ms. Wiley and other claimant counsel have been referred to in terms of having the experts get together, it would be in terms of agreement on the likely impact for the country or parts of the country in terms of what to expect from climate change and so forth, and the impact on Māori. So just in terms of other evidence that might be useful, the panel has thought that it might be useful to have evidence on the health status of Māori brought across from the health inquiry, and also in terms of the housing situation for Māori, information brought across or evidence brought across from the housing inquiry. Can I have your views about that possibility?
Apologies, Mum. Just was this a general question directed to Council? Sorry, or just?
It is a general question. Yes.
Yes, Mum.
Generally directed.
Apologies. Just before we move on from the AVL, just to note that we are one of the council that have raised concerns about the adequacy of cross-examination through AVL, and also we have claimants who live in very rural areas who have significant difficulty with connecting through AVL to hearings, and so just to raise that. Thank you, Mum.
Thank you. And I didn't mention that the panel members also have some concerns about hearing everything by AVL. But again, this is something that as we see what the evidence the final scope of the evidence and who's giving it and so forth, and whether there's cross-examination to be, that we can finalise that later down the track. But yes, the panel is thinking more about a mix as being necessary rather than just all AVL or just all in person. Well, it won't be all in person.
Thank you for that indication, Mum.
Kia ora, Your Honour, Ms. Cherrington. I'm putting up my physical hand because I can't find the button for my AVL hand. But I just want to total call Ms. Swedland, while we, and your comments around a mix, because not only with expert evidence and cross-examination, our clients also live rurally and have difficulty connecting or even having the connection at all. So I think just noting that will be something that can be fleshed out once we identify who the witnesses are and what their capabilities are at the time. But that I think there will likely be a need, as you say, for a mix of both, where possible, on the evidence side of things.
Yes, thank you, Ms. Cherrington. And then, in terms of those possible in-person hearings, it might be, again, thinking about climate emissions and carbon emissions and so forth, it might be that only those, only a certain grouping attends in person and the rest are online or whatever. So it might be just those who wish to cross-examine who attend in person and so on. So again, something, I think there's going to be a lot of organisation that we're going to have to do around how those hearings are going to take place. And we can do that later as we see the picture more clearly. All right.
I also think in terms of maintaining tikanga throughout these hearings, that perhaps the first hearing, if possible, could be kanohi ki te kanohi. That would work really well for our clients.
The question then is where, and so on. But we'll come to that. I think we'll just let that lie for a moment and for a while, and come to that when we. Because there's something to be said for Claimant Council giving their opening submissions online as well. But yes, we hear what you're saying about kanohi ki te kanohi. I'm just checking my list.
Mr. Whenua speaking, if I may also address your previous question on the desire of the panel to have evidence brought forward on the impacts of climate change on health outcomes for Māori. The impact of climate change on health outcomes for Māori is part of the claim that Mr. Sharp and I collaborated on for Y2607. So those health outcomes are expressed within the claim of Manu Paul and David Potter, and we sought to reach out to, there is a recognised public health expert, Dr. Rhys Jones, who is also a academic at Auckland University, who speaks to this topic and has done significant research on it, both domestically and globally. So he's a recognised global expert on Indigenous health outcomes as a result of climate change, particularly with respect to Māori. We reached out to him. He has been quite busy, but I think that that is something that we should do again, given that it's of particular interest to the panel. Basically, his research shows that there are significant inequitable health impacts of climate change on Indigenous communities, and that is a trend which we continue to see amongst Māori communities within Aotearoa.
Thank you, Mr. Whenua. So looking back at my list, I think we're now at the stage of me gathering from you a sense of when you think the joint statement of issues could be prepared and filed. Mr. Sharp?
Yes, not right. I'm encouraged by the comments by Mr. Prebble that he doesn't have any great issue with them. So I will we'll contact him immediately with regard to see what we could produce. But you know, I would certainly hope that within, say, the next few weeks, we could either have something produced with the tribunal or get back to the tribunal saying that we need more time.
Right. So if I, in the direction, say that is the 31st of May a working day? If it is, it is. It's a Friday. So yes, if you can file, hopefully you'll have the joint statement of issues by the 31st of May. Otherwise, yes, leave to apply for more time. Now, just the next matter is any further business, and I should raise the issue of the fact that an urgency claim application has been made by Mr. Henry Coyer in relation to issues he has on a biofuel project that he wishes to start. We are expecting his response to the Crown's reply today, and we will be giving our decision as soon as possible after that on the urgency. So I'm just noting that. Is there any other matters that anyone wishes to raise?
Your Honour, if I just could quickly jump in to clarify 2 points, and that was on the ETS and the work you're giving us as homework, if you like, and the further documentation. Is that part of what you anticipate being issued in terms of the directions today, and do you wish to put a time frame around that as well, or is that a longer term thing, just so I'm clear that it's something I can then feed into the wider Crown network, if you like?
Yes, yes, I didn't want to put a time frame because it seems to me that it might actually be quite a piece of work to do. So I don't ask you for that, but I will be putting it into the direction and asking you to respond with a time frame.
Okay.
After that.
Thank you, Your Honour.
And in terms of Council filing any of their reference materials and so forth, let's make it the 31st of May. I'm sure that you've all actually got it in your folders and boxes behind you. So I'm expecting that that won't be a problem for you to file by the 31st of May, but that will also be in the direction.
Potential claimant witnesses' names?
Yes. Professor Williams, we've had a mention of potential witnesses already today. Professor Williams has suggested that you might also think about giving us a list of your potential witnesses over and above any evidence that has already been filed. And again, I think 31st of May would be a reasonable date for that list as well. I mean, it's a potential list. It can be modified later. Anything else? Anything else that the panel's happy? Anything else that you would like to raise?
Yes, ma'am. I'm just wondering.
Oh,
sorry, I'm just wondering whether we could have an update around claimant funding from Mr. Preble, given the comments around needing support for claimants if they're preparing, substantive or extensive or even expert witness briefs.
Are you asking, will the Crown come to the party as it has done in other inquiries to support?
Yes, yeah. And if we can get that sort of, at the outset, that way we can arrange that with our claimants and know what we can, what we have to work with in terms of getting the evidence prepared.
Is that possibly something that could be in terms of offline communication, if you wanted to email me with your, I guess, request, and I could then take instructions on that, and happy for that to, I'm not sure it needs to go to the tribunal just yet, but in terms of the Claimant Council and the Crown could come back on that. I just would need to obviously seek instructions.
Thank you, Mr. Preble.
Yes, sure.
Yeah, thank you. Any other matters?
Just to finish, I just want to register an appearance for council appearing with me on the 2607-3248 claims. That's Nicole Smith. She joined the Zoom late.
Yes, and welcome, Ms. Smith. I should have said that earlier when I saw that you were online, but you're very welcome. Well, thank you all very much for joining today. This has been a very useful start for our inquiry. We've obviously got a lot of work ahead of us, but the panel is very keen about this inquiry, very interested and very engaged, so we're looking forward to it, and I hope you are too. And I will just ask our Mr. Prime to close for us.
Kei nei tātou. E pae tō mātou i te rangi. Tēnei mātou e tuku anu te reo whakawhetai ka moimiti ki a koe pāma ngana nākitanga iuhi mai e koe ki runga mātou I roto I tēnei huihuinga mai te timitanga I te ata nei taino ki tēnei ahora haka mutunga. Tēnei tonu te whakawhetai, te whakamoimiti tau ingoa te akatoke te kororia ki a koe. Me te ina ati ki manākiti ana koe tēnei o mātou, e uhe et kini o mātou kāinga. Manākiti ana hoki ngā roia ki te whakatutuhi ngā mahi mō rātou kai kreme. Hei paingana mou, hei paingana mo te iwi whānui, hei whai pāngana ki tēnei kaupapa. Ko te ina ko tēnei ki a koe pā maune whakamana mai. I runga nei tingua tāu tama te kai whakoro koe ukaraiti. Āmene. Kia ora tātou.